Hearing in the appeal of UBS AG and DB Group Services against Commissioners for Majesty's Revenue and Customs.
My Lords, I appear on behalf of the appellants, to whom I shall refer probably as either the Commissioners or HMRC, and I appear with Mr. Vallet on my left and Miss Blackwood on my right. My learned friend Mr. Prosser, QC, appears on behalf of UBS, and my learned friends Mr. Goy, QC, and Miss Shaw, QC, appear on behalf of Deutsche Bank, to whom I shall probably refer as either Deutsche Bank or DB. My Lords, my oral submissions will take approximately 1 hour. Now, I've done that calculation without taking into account questions from the court, but that was not intended to be a challenge. However, I think that it will not be over an hour, but it will be pretty close to an hour.
We'll try and assist in that.
In the course of making my submissions, I'll refer on occasion to passages in the printed case of the respondents. And what I will do is I will summarise what they say, indicate the paragraph and also the page number, and I'll use page references.
Right.
Unless one of your lordships would want me to do so, I will not actually ask you to read the passage. I'll just summarise it and give you the reference. The structure of my submissions to you today is going to be as follows. I'm going to make some introductory observations, starting off with a synopsis of the reasoning of the Court of Appeal. And then I'm going to look at the Ramsey doctrine in 2 parts. I'll look first at the realistic appraisal of the facts and then at purpose of construction. Now, so far as the reasoning of the Court of Appeal is concerned, taking the reasoning from paragraphs 62 to 66 of the judgment as being where the reasoning is largely to be found, yes. Paragraph 62 also contains a cross-reference to earlier paragraphs in which submissions made, in particular, I think, by Mr. Prosser, are summarised and which are adopted. And in particular, it's submissions at paragraphs, summarised at paragraphs 54 to 56.
Thank you.
But taking paragraphs 62 to 66, the reasoning of the Court of Appeal is broadly as follows. The Court of Appeal says that the shares given to the employees were real shares. They were not the equivalent of money because what the employee received on redemption might very well be different from what was originally paid by the shares. The forfeiture provisions couldn't be ignored because there was a genuine possibility of a forfeiture happening. And Chapter 2 of the Act is a detailed and prescriptive code which doesn't leave room for the exclusion of an arrangement from the scope of the chapter simply because the arrangement is driven by considerations of tax avoidance. And on that last point, the Court of Appeal seems to have thought that an examination of the purpose lying behind Chapter 2 was not useful for 2 reasons, and this goes back to paragraphs 54 to 56. And the 2 reasons were, firstly, that Section 429, which is the provision that removed the charge to tax, had no discernible purpose, and secondly, that Parliament had dealt with tax avoidance in Chapter 3A, but not in Chapter 2, leading to the inference that Chapter 2 was intended to apply just as much to tax avoidance arrangements as to any other type of arrangement. Now, we submit that that reasoning is wrong in law because it doesn't correspond to the modern understanding of the Ramsey doctrine and the Court of Appeal's views concerning the purpose or lack of purpose of the provisions of Chapter 2 were also misconceived. So far as Ramsey is concerned, it's common ground, and I suspect that it's stating the obvious, that Ramsey has got two limbs, a realistic view of the facts and a purposive approach to the construction of the relevant statutory provisions. And understood in that way, Ramsey is largely concerned with the difference between formal and substantive compliance with legislative requirements.
You want to tell us at some point whether we're on the realistic view of facts limb or the purposive view of the statute limb, or both?
Yes, I will introduce each. This is part of my introductory observations, and when I get to each section, I'll tell you which section it is.
Thank you.
So Ramsey, in our submission, proceeds on the basis that fiscal legislation is generally concerned with substance or with commercial reality rather than form. And that explains why facts are to be viewed realistically. But Ramsey, in our submission, doesn't exclude the possibility that a purposive construction of the relevant legislative provisions may indicate that form alone or ticking a box suffices. It may do. But the point of the doctrine is to get away from a generalized assumption that formal compliance with the literal meaning of legislation always gets you home. And in that connection, the Court of Appeal's view that Chapter 2 is detailed and prescriptive, which is a refrain taken up by the respondents in their written cases, is not particularly relevant or informative. In a case such as the present, where the schemes we submit sought to achieve formal but not substantive compliance with the legislation, the critical question is whether or not the legislation purposively construed was satisfied with formal compliance or required substantive compliance. And that question isn't answered by observing that the legislation is detailed and prescriptive, because even detailed and prescriptive legislation is perfectly capable of being concerned only with substantive compliance with its terms. I'm turning now to the realistic view of the facts, which I take first because in a lot of the cases that is what the courts do. It's useful to look at the facts first rather than take the legislation first, because then you're not looking at the legislation in the abstract. And I would like to make two preliminary observations. The first is this. It's necessary to emphasize a fundamental error in the approach taken by the respondents. And I'll take this from UBS's printed case, for example.
Yep.
UBS, the relevant passage is paragraphs 37 and 51 to 52 at pages 98 and 105. Now, UBS assumes that the Commissioner's objection to the schemes is based on nothing more than the fact that they were tax avoidance or lacked a commercial purpose. And that, therefore, the Commissioner's case can be answered by taking the line that the statutory provisions were highly prescriptive and detailed, so that they must be construed as not excluding tax avoidance schemes. By implication, their case is that where a tax regime is detailed and prescriptive, its purpose must necessarily be to apply to or to accommodate tax avoidance arrangements, whatever form the avoidance takes. In our submission, that misses the point entirely. It has never been the Commissioner's case that a finding that transactions have tax avoidance as their sole or predominant purpose automatically causes the nature or substance of the transactions in question to change in all cases. For example, suppose that an employer has a choice between rewarding an employee with cash or with shares. And suppose that for some reason the employer decides to choose shares solely in order to avoid tax. Now, the intention to avoid tax does not, in that example, alter the reality or the substance of what he has done. The Commissioner's case is very different from the one hypothesised by UBS and also by Deutsche Bank. It is that, taking into account the totality of the facts and viewing the totality realistically, the Deutsche Bank and UBS schemes don't fall within the statutory provisions here in question because the schemes were designed to achieve only formal and not substantive compliance with the legislation. To take up the point made in the last sentence of paragraph 42 of Deutsche Bank's written case, which is in the Deutsche Bank appendix at page 595, in relation to these...
42 of what, sorry?
It's Deutsche Bank's printed case.
The Deutsche Bank.
I do apologise.
No, it's entirely my fault.
It's paragraph 42.
Yep.
At page 595, and it's the last sentence.
So I was just looking in the wrong bundle. It was entirely my fault. Thank you, yep.
So, taking up the point that Deutsche Bank make, we submit that in relation to these schemes, the award of the shares is to be treated as cash because that is the reality of the situation. And at this point, it might be helpful to mention a distinction to which I'll come later. There are some cases in which a tax avoidance motive is relevant to the tax treatment of a transaction because it's a feature that the legislation has determined should be relevant. And the examples in the present case are the provisions in Chapter 3A, in particular sections 446 capital B and 446 capital E. Those provisions affect the taxation of restricted securities where certain things are done, and I quote, otherwise than for genuine commercial reasons, unquote. And that phrase would include tax reasons. Now, it might be possible to imply such a requirement into a particular statutory provision, but it's certainly not the Commissioner's argument in this case that such a requirement can generally be implied into all fiscal legislation. Now, in other cases, the tax considerations of the taxpayer are relevant because they inform the structure chosen by the taxpayer, and in consequence they inform the real view of the structure to be taken in assessing the tax liability. For example, if one knows that a given provision was inserted purely for tax reasons, has no commercial purpose, and only a de minimis commercial effect, it may be appropriate to disregard that provision when deciding whether the facts answer a particular statutory description. And that is, we say, how the tax avoidance purpose of the appellants is of the respondents in the present case is relevant because the purpose comes through in what they actually did. And for the sake of clarity, it may be useful also if I confirm that we're not saying that we're looking at sham transactions in the traditional snook sense, nor are we at this point saying that these are Street and Mountford type cases. Now, the second preliminary point, that was a long preliminary point, this one is going to be a shorter preliminary point, concerns the approach taken by the Court of Appeal. The Court of Appeal's approach was based on isolating particular facts and drawing inferences from them without looking at the factual situation as a whole. So, for example, the Court of Appeal acknowledged the existence of the schemes, but then put them on one side. The shares were looked at from one aspect only, the fact that, particularly in the UBS scheme, the cash received ultimately by the employees wasn't a preordained amount, but could be different from the cash initially put into the scheme. The other aspects of the shares were ignored. And the forfeiture provisions were considered in isolation and only by reference to whether or not there was a possibility of forfeiture occurring. Now, previous cases on the Ramsey approach, and we cite them in our printed case, don't support the Court of Appeal's approach of taking a selective view of the facts instead of looking at the matter in the round. And an example of looking at the matter in the round is paragraph 19 of Lord Nichols' speech in the Scottish Provident case, which is in the Authorities Bundle, Volume 2, at tab 20, and it may actually be useful just to have a quick look at what he said. So it's tab 20, and the E page is 1660.
Yes.
And I won't read out the paragraph out loud. It's sufficient if you're...
So which page of the...
It's page of the report, it's page 25. Of the bundle, it's E1660.
My bundle doesn't have E numbers on it.
I apologise.
So, but...
Bottom left. Yes.
But it's page...
Oh, it does. Okay.
Paragraph.
And it's paragraph 19.
Thank you. Yes, I see.
So that's an example of the necessity when viewing the facts realistically to look at the facts in the round and in the surrounding commercial and factual context. If we turn...
No genuine commercial possibility of the two options not being exercised together. Is that the point?
Yes, because, and I use that as an example, which is relevant to the present case, because what we're looking at here are precisely coordinated schemes. The schemes have got to be looked at in their entirety because that's what they were. You can't just split them up into little bits and take one part in isolation and analyse that outside its context. That is not real. And I'll explain in a couple of minutes why that is so.
At some point you'll explain how the fact that Section 429 had no discernible purpose fits into all this. It seems to me rather difficult to look at the reality of the situation when you're looking at it against the background of a statute which seems to be unreal, has no purpose.
Well, I'll come to the purpose of Section... I was going to make specific submissions on the purpose of Section 429, and that is, if you allow me to do so, that's in my section when I look at the purpose of construction of the law. But looking at the facts for a moment, It's plain from the facts found by the first-tier tribunal that Deutsche Bank and UBS did not give their employees shares by way of a bonus, and they had no intention of doing so. What they did was to invite their employees to participate in a detailed and prescriptive scheme. The details of the scheme were explained to the employees in advance so that the employees knew what they were agreeing to when they decided to participate in the schemes. The documents showing what the employees were told are as follows. In the UBS bundle in the appendix, there are two documents. One runs from page 344 to 362, and there's a later version of it at pages 430 to 447. The reason why there are two versions is because originally the UBS scheme provided for two opportunities for the employees to get their cash out by redeeming the shares, and later the scheme was changed to specify 3 times at which the employees were to get their money out of the scheme.
Thank you.
The document in the Deutsche Bank bundle, there are actually two. There is a presentation given to employees by Deloitte, which is at pages 818 to 832 of the Deutsche Bank bundle. And there were also letters sent out to the employees, and an example is at pages 838 to 845. Now, under the instructions given to the employees, if they wished to participate in the schemes, they indicated to the employer their preference, specifying the amount of money that was to be awarded to them by way of bonus, but that would be put into the scheme. At that point, the schemes were similar in nature to, for example, the arrangements at issue in the recent Court of Session case decision in Murray Group Holdings, which I don't need to go to in any detail. That's in the Authorities Bundle, Volume 2, tab 21. In referring to Murray Group Holdings, I am not resurrecting a point about Section 18 of the Act. I'm looking at a slightly different aspect of what was going on. But under the Deutsche Bank and UBS schemes, when the employees indicated their preference, they weren't asking that shares were to be given to them as bonuses. They were opting for the application of the scheme in its entirety to the cash award. And as the first-tier tribunal found in relation to the Deutsche Bank scheme, and this is a finding at paragraph 109 of the Deutsche Bank decision, that is in the Deutsche Bank bundle, the tab is E2, the page is 780. And if you go to page 780 and look at paragraph 109, it's the second sentence in the paragraph, which begins at the end of the first line, quotes, "The reality in this case was that the appellant and others undertook a series of the appellant, of course, there is Deutsche Bank, undertook a series of closely coordinated events that were funded entirely by Deutsche Bank so that its funds were transferred to its employees as agreed with them, unquote. Now, these are not cases in which an employer gives an employee shares by way of bonus, or even asks the employee if that's what he wants, so that the employee then goes off and enjoys the benefits of share ownership and takes the risk of share ownership as he wishes. The purpose of the schemes was to get the cash that the employee asked to be put through the scheme out again at the earliest opportunity without incurring liability to income tax or national insurance contributions, unless the employee wished to take advantage of capital gains tax taper relief when he got his cash out, in which case the monies would be left in the scheme for a longer period of time. But that means in our submission that Deutsche Bank errs when it says in paragraph 34 of their written case, which is page 593, that the commissioners are asserting that because the employees were awarded shares instead of cash bonuses, and because the shares can be redeemed for cash, the shares should be treated as if they were cash. That's not the Commissioner's case at all. The fact that the schemes started with cash and ended with cash was not the consequence of the fact that shares, by their nature, can be turned into cash. That wasn't the reason why the schemes began and ended with cash. They began and ended with cash because that was what the schemes were about. And that explains the focus in the schemes and the way in which they were implemented on the procedures and the timetable for redeeming the shares for cash. And I mentioned earlier that there are two versions of the UBS prospectus given to the employees, and the main difference between them is the specification of two opportunities to redeem the shares for cash, which is in the first prospectus, altered to 3 opportunities in the later prospectus.
Can I just pause a moment? You're relying on, at page 780, on the findings of the first tier tribunal.
Yes.
And are you suggesting that those are findings of fact which somehow are immune from review, or what?
Well, I was wondering when somebody was going to ask me that question. The realistic view of the facts part of Ramsey in our submission is a factual evaluation which can be challenged on traditional, well-accepted Edwards and Bairstow lines. The challenge launched against the conclusion of the first-tier tribunal was based essentially on the legal argument that the shares were shares, therefore end of question. Now, we submit that that is simply the wrong approach to take. That's an argument, ultimately, of law rather than appreciation of facts. If it is right that the assertion that the shares were real shares is not the answer to the question, but you have to look further into the substance of what was going on, then it's, in our submission, legitimate to go back to the fact finder and see what the fact finder actually held in the light of the evidence that came before it.
Yes.
So,
I mean, I don't want to overplay this, but as you're aware, in Pendragon, I expressed certain views and the agreement of my colleagues on the sort of balance between the upper tribunal and the first-tier tribunal. And also in Furness and Dawson, it was decided that the question of what is a scheme was a question basically of fact. And if you're going to rely on a finding in the first-tier tribunal, then we'll need to see to what extent that sort of stood the review of the upper tribunal and what's left of it as far as we're concerned.
Well, that finding was not. The problem is that the approach before the upper tribunal was at this rather higher level of saying what you should examine is the reality of the shares.
Yes.
I'll take that as an example because that was not the only point. But when you look at this other approach, which was the one that found favour with the first-tier tribunal, the upper tribunal did not disturb.
You're saying that if the upper tribunal had the wrong focus, as you say they
Yes.
did, then we're entitled to go back to what the first-tier tribunal found.
Yes. And it is certainly the case that if the upper tribunal overturned a view to which the first-tier tribunal had come, and that hasn't been appealed, well, that's the end of that. You can't go back to the first-tier tribunal in order to resurrect that point.
Okay, well, I understand the way you put
Yes.
it, and I just wanted to flag it up as a point.
Yeah. Now, I reached the point at which I was emphasising the focus in the schemes on the processes and the timetable for redeeming the shares for cash. Now, also associated with that are the facts that the shares given to the employees were in companies specially created for the purpose that had no actual business and were intended to exist only for as long as was required for the purposes of the schemes. Now, one asks the question, why would any of that have been done if the purpose of these arrangements was simply to give the employees shares? Because if you want to give them shares, you just give them shares. Why do you create this structure? Why do you have this emphasis upon redemption of the shares for cash? What's it doing there? And in our submission, none of all this would have been done, and it wouldn't needed to have been done, if we were talking about the giving of shares by way of bonus. The fact that it was done, and the emphasis placed upon it, shows what, in reality, the schemes were about. And in that respect, one recalls a comment made by Lord Hoffman in the McNiven case about this type of arrangement.
Yeah.
McNiven is in the Authorities Bundle, Volume 2,
Yep.
at tab 16.
Thank you. Yep.
And
Where do we look at that?
the passage is at page 1504, and the report, page 337.
Yes. Paragraph.
It's paragraph 68,
Thank you.
and it's his comment on the NMB Holdings case. This was the Platinum Sponge case, in which directors were remunerated by Platinum Sponge, bought by the company, bought by the employer, given to them, which they then sold in order to realise the cash value of the Platinum Sponge. And round about letter H, Lord Hoffman refers to the payment of the bonuses in the form of Platinum Sponge, and he goes on to say, accompanied by arrangements under which they could immediately sell it for cash to the bank. And he says, that wasn't a payment in kind. He's there, of course, referring to the Social Security Contributions Regulations 1979. He says, in commercial terms, the directors were paid in money.
Sorry,
Bottom of page 1504.
Yes, I-
1504.
oh yes, I see, yes.
So you're saying in that case, as you say in this case, payment in money was being dressed up
Yes, that's right.
in other clothes.
But rather like the NMB Holdings case, if you were talking about the payment of a bonus in the form of, I don't like to use the phrase in the form of because I have been drawing a distinction between form and substance, but your lordships know what I mean. If you have got a director being given platinum sponge by way of bonus, well, he gets platinum sponge. But why was the arrangement then coupled with arrangements for the realisation of the platinum sponge to turn it into cash? Now, it's simply a realistic view of the facts that in that type of circumstance, the commercial realistic view is you've got cash transmuted into something else, but it's done that's being done for a particular reason, but it's going to be transmuted back into cash again. That's what the arrangements considered as a whole are all about. And so our submission is that this is exactly the situation that we've got here. The schemes can't be understood if one chops away the parts of the schemes that deal with the redemption of the shares for cash. Because those parts in our submission, as a matter of the straightforward commercial reality, were integral to the scheme. They were interlocking with the rest of the scheme. They can't be just hived off or ignored. You have to look, in our submission, at the totality. For example, if one looks again at the shares, they actually had no meaning, purpose or function outside the context of the schemes, and they weren't intended to have any independent meaning, purpose or function. In that context, I can refer to a finding again in the Deutsche Bank decision. This is the tab is E2, and this time it's paragraph 112 of the Deutsche Bank decision of the first tier tribunal, which is at page 781.
112.
112.
Yep. Yeah.
And in 112, page 781,
Yeah.
the evaluation of the first tier tribunal is that DBI, the company in which the restricted securities were held, was therefore in reality purely a vehicle for the scheme. And then the first tier tribunal says, quotes, the C1 shares were created solely so that they could be treated as restricted securities within Chapter 2 and not for any other purpose, unquote.
Right.
So what we're talking about is arrangements that didn't have any independent meaning. They were not like shares in the ordinary sense in which we encounter shares in commercial life. And added to that particular finding, there is the obvious fact that the company used in the Deutsche Bank scheme never had any business, and its assets were nothing other than the cash bonuses themselves, which were invested in investments such as gilts that were as close to cash as possible. It wasn't an ordinary commercial venture at all. In the UBS scheme, the shares were held in a company called ESIP, which used the cash bonuses to buy shares in UBS. But clearly, if UBS had intended to reward its employees with shares, the simplest and most obvious course would have been to have given them UBS shares. So what was the purpose of interposing the ESIP company and having this structure? Well, it was needed because of the role of the SIP company in routing the cash bonuses to the employees without, it was intended, any liability to income tax or national insurance contributions.
So you're saying, in effect, that the shares that we're dealing with here are like the platinum sponge. They exist, but they've no function other than as a means of obtaining cash.
Yes, they're tokens for cash.
Yeah.
Now, I need to deal with one point that was influential before the Court of Appeal, and that was the possibility of there being a divergence between the cash amount put into the scheme and the amount that was taken out, or might be taken out. In our submission, the weight placed by the Court of Appeal on that factor was misplaced, because any divergence of that sort, which in the Deutsche Bank scheme was virtually non-existent, was purely adventitious. The essential point in our submission is that the schemes weren't designed as rational investment opportunities. In the Deutsche Bank scheme, one sees that from the vehicle used for the scheme and the investment policy that it was required to follow, which was this very, very conservative investment policy, not an ordinary commercial one, which was designed to maintain the value of the cash bonuses. In the UBS scheme, the evidence was that tax avoidance was the only reason why an employee would enter the scheme, and that's referred to in the first-tier tribunal's decision in the UBS case at paragraph 138. It's taken from the evidence of one of the witnesses, and it occurs at the bottom of page 322 and the top of page 323. Now, when you've got evidence that employees would not enter the scheme at all, otherwise than for tax avoidance purposes, you've got a finding in our submission that using the SIP shares as real shares was not what the UBS scheme was about. It was just the use of these shares as tokens for cash. Now, in contrast to a rational investment opportunity, which implies that shares might be kept or held by the owner of the shares, and a decision whether or not to dispose of them would be made by the normal range of factors that an investor will take into account. In contrast to that, these schemes were devised with the object of taking the cash bonuses put into the schemes out in cash as soon as possible, or at a time dictated by reference solely to fiscal considerations, not commercial ones. Because there was no commercial reason why anyone would keep their money in the schemes for any longer. Any increase in the amount taken out was just a fortuitous byproduct of the avoidance nature of the schemes. The forfeiture provisions, when taken in context, suffer from the same defects. The schemes weren't designed to put the employees' bonuses in peril or to expose the employees to the kind of risk that ensues when someone is given shares to use as they wish, or when shares are subject to a forfeiture provision in the real world. In the Deutsche Bank scheme, the forfeiture provision applied between 7th of February and the 2nd of April 2004, a period of about 3 weeks, for no discernible reason other than as a token obeisance to the requirements of the legislation. Whether or not the forfeiture provision was triggered was within the control of the employee, who had an obvious interest in not triggering it. One employee did trigger the operation of the forfeiture clause, and he got cash. And that's a finding made by the first-tier tribunal in paragraph 106 of its decision in the Deutsche Bank case at page 780. In the UBS scheme, the restriction used to turn the shares into restricted securities was an external event that is admitted to have been a commercially irrelevant contingency, and whose likelihood of occurring was found by the first-tier tribunal to be improbable. The practical effect of the forfeiture provision was deliberately intended to be nullified by a call option. And I need now to make a few comments about the call option in the UBS scheme. The background to this
Could you
is...
give us, the reference to that finding?
I was going to come to it. The finding of improbability is paragraph 111 of the decision of the first-tier tribunal, which is at page 316.
Thank you.
And the discussion of the call option, its background and so forth, starts at paragraph 99 and runs through to and includes paragraph 111. And there's also a bit about it in paragraphs 135 to 137. The page numbers are 313 to 316 and 321 to 322. Now, I think actually it would be advisable just to have a look at parts of this. If you go to the Deutsche Bank decision, which is the tab E2, you've got I'm sorry, this is I'm in the wrong bundle. It's the UBS decision, not the Deutsche Bank one.
This is UBS.
And so it's E2.
So which one are we looking at, UBS or Deutsche Bank?
We're looking at UBS.
Fine. So it's E315
Yeah,
in the call volume of the UBS.
that's right.
Okay.
So in paragraph 105, there'd been in the preceding pages an account referring to the background documentation about the origins and development of the call option. And you get at paragraph 105 the start of some conclusions made by the first-tier tribunal. In the third line of paragraph 105, the first-tier tribunal says, quotes, "The aim was at first that there should be a complete offset between the loss to an employee if the trigger event occurred with the result communicated to senior management that there would be no reduction in value in the payout to the employee. He or she would receive the same whether or not the trigger event occurred. At some point, someone thought a deliberate near miss was better than an exact hit in terms of offsetting the loss. As the trigger event didn't occur, this was not tested," unquote. And so in 106, you've got the conclusion that the scheme was carefully designed so that the employee wouldn't suffer any significant loss if the trigger event was realised. 107 refers to the fact that the trigger event was deliberately chosen as an objective limited risk that a counterparty, that was the counterparty under the hedging arrangement, was prepared to offset entirely. And the reference to it being an improbable event is at the end of paragraph 111. It's the penultimate sentence. So you had a minor effect resulting from an improbable event. It is, however, important to be clear about what this call option was doing. The commercial purpose of the call option, for the avoidance of doubt about this, before the upper tribunal, I said that the call option was the only commercial element in the UBS scheme. So when I talk about the commercial purpose of the call option, I don't wish to be interpreted as accepting that there was any other aspect of the UBS scheme that had any commercial purpose at all. But the call option did, and its commercial purpose was to ensure that, broadly speaking, the amount received by the employee on a forced sale of the shares would be equivalent to the cash awarded to him by way of bonus and put into the scheme. Now, this case, like the Deutsche Bank case, concerns, inter alia, section 4232 of the Act. And if your Lordships will be kind enough to look at section 4232, which is in the first authorities bundle, at tab 2, and the page reference is 1088 to 1089. We've got 4232 at the bottom of 1088 says that that subsection applied to provision under which, and then you have three...
Well, which E number is it?
I'm sorry, this is E1088 at the bottom.
Thank you.
And the relevant part is actually at the top of 1089.
Thank you. Yes, I see.
And so at the top of 1089, you've got three cumulative conditions.
Yes.
So there had to be a transfer, reversion, or forfeiture of the securities.
Yes.
B says that as a result of the transfer, reversion, or forfeiture, the person holding them ceased to be beneficially entitled. And then C says that essentially as a result of or at least on the transfer, reversion, or forfeiture, you don't get an amount of at least the market value of the security. Now, the point here is that section 4232, like the rest of chapter 2, proceeds on the basis that the employee has been given restricted securities that have their own intrinsic value, and that's the relevant value. It doesn't contemplate a situation in which what the employee gets is effectively a token representing cash, so that the value that is important and relevant to the employee lies elsewhere. And in the UBS scheme, the sensitivity was about a threat to the cash value of the employee's bonus. And it was that which that sensitivity led to the use of the call option, because the call option was intended to protect the cash value of the bonus in the event that the trigger event occurred. But if that was what the sensitivity was, if that was what the concern was, if that was what was regarded as relevant to the parties to the scheme, then it is a sure indication that what they were concerned about, the real value that they were looking at, was the cash amount put into the scheme. They weren't actually concerned all that much about the shares. So that the fact that the call option was designed to protect the cash value put into the bonus, in our respectful submission, is significant because it indicates the true nature of what was going on and what the employer and the employee were really concerned about, and what for them was the real value that they were seeking to safeguard.
Is a problem for you in the submission that they didn't care all that much about the shares? I mean, is that enough?
No, because in our submission, the point is that this indicates that what they were really interested in was the underlying cash.
Sorry, I'm just playing with words almost, but you said all that much about the shares. You're really saying they didn't care about the shares?
You don't. What you had was a situation in which the value of the shares would go up on the hypothesis that the trigger event was occurred, and as a result of that, the forfeiture would occur. But the effect of the call option was not actually to protect the value of the share; it was to protect the value of the initial cash bonus.
Yes.
So, because that was what they were looking at, it shows that that was what the scheme understood in the round was about. It wasn't about the shares per se. The shares were just there as tokens for the cash. Now, the fact that what they did was to contrive a deliberate near miss rather than an exact hit in our submission is just irrelevant, because the intention was not to expose the employee to the risk of losing his cash bonus as a result of the existence of the forfeiture provision. The deliberate near miss was the kind of contrivance that one is entitled to ignore. Now, in my submissions thus far, I have repeatedly used the phrase tax avoidance and also the word avoidance in connection with these schemes. But that repeated use shouldn't be interpreted as being simply pejorative. The schemes were directed at nothing more than formal compliance with the statutory requirements literally construed. And viewed realistically, they were, for the reasons that I've given, just about payments of cash. And this brings me now to the purposive approach to the statutory provisions. The Commissioner's case is that, purposively construed, those provisions require substantive compliance with their terms and aren't satisfied by mere formal compliance. The general effect and purpose of Chapter 2 were to deal with the taxation of securities whose value was depressed by the existence of a restriction affecting the security. And the type of restriction envisaged in Section 423, subsection 2, which we looked at a moment ago, is one that threatens the employee with the loss of the securities so that he loses the value represented by them. And I've earlier made the observation that Chapter 2 proceeds on the basis that the value that is relevant, and I might add commercially relevant, is the intrinsic value of the security given to the employee. And the chapter doesn't actually contemplate the situation that arises where the commercially relevant value is elsewhere. And the UBS case is a graphic illustration of a situation where the commercially relevant value is elsewhere. But at all events, the solution adopted in the legislation was to postpone the chargeable event until the subsequent removal or variation of the restriction, and there are complicated provisions dealing with how you apply the tax. Although the statutory provisions were detailed and prescriptive, in our submission there's no reason to believe that, viewed purposively, they could be satisfied by purely formal compliance with them. For example, on the face of it, Section 4232, the restriction provision that we've looked at, contemplates the existence of a real threat to the securities given to the employee, which, if it materializes, would leave the employee worse off than he had before. It would deprive him of that which the employer wished to give him, or had given him. The policy decision to defer the point at which tax is charged makes sense when the employee is faced with such a threat. Now, this is very far removed from a different kind of detailed and prescriptive statutory regime, which we see in the Court of Appeal decision in Mays, which is in the authorities bundle. It's the second volume at tab 17. In relation to that case, I'm only going to refer to a short paragraph at the end of the Court of Appeal's decision. It's from the judgment of Lord Justice Toulson, as he then was. So if you go to Mays tab 17, it's the penultimate page of the report, and the E page number is 1584.
Yes.
And in paragraph 103, he says, quotes, inherent in the scheme, and he's there referring to the statutory scheme, is the possibility of a disconnection between what would be regarded as a gain on an ordinary commercial view and what is to be treated as a gain for the purposes of the statute, unquote. And the problem in the Mays case was that you had this disconnect between commercial reality and what the statutory regime required. And in our submission, it was that lack of connection that enabled the tax planning in Mays to succeed. It wasn't the fact that the statutory provisions were complex or detailed and prescriptive. It was the particular type of technique that was used in the statutory regime in that case. But there is no basis for believing that that same technique was used when we look at the provisions of Part 7 of the Act, and any such suggestion is negatived by the observations of Lord Walker in the Gray's Timber case on Part 7. I turn now to Section 429. I do observe that I have broken my promise to your lordships.
Just before you do, can I just ask, it rather sounds from the way you've presented the argument so far as though your point is more fundamental than saying that we don't have here forfeiture provision within the true meaning of Section 423. It sounds as though one could put it more fundamentally, that these instruments are not securities within the meaning of this legislation.
We're appealing on two grounds. The broad Ramsey ground is that we're just not in Chapter 2. The narrow Ramsey ground is this more focused argument on Section 423(2).
Well, I wonder if the broad one can't be put in an equally focused way. I mean, it rather sounds as though you're saying that what we have here these instruments happen to be shares. It might as well be monopoly money or tiddlywinks, but they happen to be shares. But they're not what Parliament had in mind when it referred to securities in this legislation. Because they simply function, they're of no inherent value, they function as tokens for conversion into cash.
That is the point that we're seeking to make. So, but now turning now to Section 429.
Right. Is that how it was put below? I mean, I'm not.
Well, I've always put it like that.
Yeah.
I don't think I've used the phrase token for cash all the time.
Well, the link with the platinum sponge was sort of.
Platinum sponge has always been there.
It's always been there.
It's always been our case that Chapter 2 just didn't apply because I did use the phrase cash in, cash out.
Yeah. Right.
And that.
Anyway, never mind. You're making the point here, and we've got to deal with it.
Yeah. Now, if we could turn therefore to Section 429, which is in the First Authorities bundle at I think it's tab 2 at page 1091. Right.
Yep.
Yeah.
It's got that.
So this is the cases outside the charge to tax under section 426. And to begin with, section 429 is an exception, and ordinarily exceptions are to be narrowly construed,
Yes.
which counts against regarding section 429 as being satisfied by purely formal compliance. It removed the charge to tax in two situations involving shares. We're only concerned with the second situation, which is covered by subsections 4 and 5.
Right.
And that situation is one where both the restriction dampening the value of the employment-related securities and the event causing the restriction to be lifted or varied are not peculiar to the employment-related securities but affect the entire class. And they've got nothing to do with the employees or the employee's relationship with the employer because they affect shares held by people who are not employees. And the policy decision was not to impose a section 426 charge because any increase in value of the shares resulting from the removal or variation of the restriction didn't inure to the benefit of the employees because of the employment relationship. It benefited all the shareholders as a class. In order to ensure that the removal of the section 426 charge was focused on its true objective, and in order to counter the possibility of avoidance, section 429 subsection 4 provided that the majority of the shares affected by the restriction must be held by unrelated persons. Now, the fact that section 429 removed a charge to tax is in itself indicative that Parliament must have been envisaging a situation that, it was considered, could be encountered in ordinary commercial life and required special tax treatment, as opposed to an artificially contrived situation or a purely formal state of affairs. The situation actually contemplated by Parliament is that where the majority of the shares in question are held by persons unrelated to, in short, the employees and to associated companies. There's nothing special or peculiar about the minority held by the employees because the provision making the shares restricted securities applies across the board. It applies to the employees' shares because they are within the class of shares in question, not because they're employment-related securities. And the requirement that the majority of the shares must be held by unrelated persons is significant because that indicates that the situation envisaged by Parliament is one in which the shares are shares in the true sense, held in order to receive the normal attributes of share ownership. The restriction is necessarily commercial in nature, and the risks associated with it are real. That has to be so because the shares must make sense as shares, and the restriction must make sense as a restriction to the unrelated persons who can be expected to view the shares and the restriction in commercial terms. After all, they don't benefit from the regime in Chapter 2, and therefore there's no reason to assume that in the situation contemplated in subsection 4, the unrelated persons even could be persons considering the avoidance of the section 426 charge for their own benefit. Now,
I'm sorry. Could you help me a bit more with this? Because I'm not sure I think I may have misunderstood it. If you have a case that falls within section 429, at what stage is tax payable in respect of the shares?
Well, there's no charge on acquisition. There is no charge that the operation of 426 is removed, and therefore there is no charge.
That's what I thought. I thought I must have misunderstood it.
No, that's the...
So, I mean, this seems very odd. I mean, we start off with Abbott and Philbin.
Yes.
And a tax charge on acquisition or on receipt of the shares. Parliament then intervenes in a situation where calculating the tax at that stage might not be a realistic assessment of the based on the true value, and so we wait and see. Okay, 429 excludes from the operation of 426 a charge on the occurrence of a chargeable event, the case where the restrictive provision is something that applies to all shares of this class rather than specifically these employment shares. I understand why in that situation you might exclude it from 426, but why exclude it entirely from all taxation?
The reason, it's a policy decision, and it was a decision based on the view that because the restriction applied to everybody in the class, and therefore it wasn't specifically related to the employment-related securities. What happened when the restriction was removed or varied, leading to an increase in the value, was something that the employee gained not because of his employment. It was something that he gained because he was a member of a broader class of shareholders. And so that was the policy decision. Now,
well, the increase in value isn't attributable to his employment, but the initial value is.
yes, but the policy decision that was made was the policy decision that was made. And I'm stuck with this.
Yeah.
I'm also, I'm a taxpayer myself. And I might have personal views, which this court is not interested in, about provisions of this nature. But Parliament is supreme in its wisdom and enacted this provision for, no doubt, sound reasons. It should be pointed out that the rationale for Section 49, this explanation, is the one that I have given, I think, at every stage in these proceedings. It was certainly the one that I gave to the Court of Appeal because it's recorded in the transcript. It didn't find favour with the Court of Appeal. It's derived from what Section 429 actually says.
With a good start.
There is a criticism that can be made of it, which is that the wording of Section 429 isn't tight enough to restrict the operation of Section 429, and in particular 429(4), to the type of situation that I have described. But that criticism of the point is not relevant for present purposes, because for present purposes, the question that we are examining is whether or not Section 429, as an example drawn from Chapter 2, but a relevant one, envisages and is satisfied by purely formal compliance as opposed to substantive compliance with its terms. And our submission is that Section 429(4) envisages what Parliament considered to be a real-world situation that it wished to tackle in a particular way. It wasn't contemplating applying Section 429 to an artificial situation brought about for wholly tax avoidance reasons. And I emphasise the word artificial, by which I mean lacking in substance. And that interpretation of 429, that is to say, an interpretation that says that it is concerned with the substance, not the form, is all of a piece with the rest of Chapter 2. Because Chapter 2, on any view, is addressing practical problems that arise in the real world when an employer gives an employee something by way of remuneration, the restricted securities, that inherently requires special statutory provisions in order to get the fiscal treatment right.
Yes.
And in our submission, it's no answer to that argument to say that, read literally, the statutory provisions don't exclude their application to arrangements that just seek formal compliance with the statutory requirements, but have got elements indicating that the substance of what is being done is completely different. In order to make good that argument, that is to say, the argument that formal compliance is enough, it's necessary to show that, construed purposively, the statutory provisions are content with purely formal compliance and don't require the situation that they contemplate to be brought into existence as a matter of substance.
Does your purposive construction, having regard to 4294 and 5, does it go as far as suggesting that the trigger for the 4232 transfer has to be employment related? Or you're not going that far?
No.
Don't go that far.
No, and the thing about 429 is premised on, we submit at any rate, is premised on a restriction that isn't employment related. Because it's something that applies across the board to the entirety of the class of shareholders.
Yes, but if you haven't got something that applies across the class of shareholders, and therefore you don't come within 426, does that envisage that the chargeable event that gives the 426, so does that envisage that the 423 trigger ought to be an employment-related trigger?
No, it doesn't have to be.
It doesn't have to be. No. I see. Okay.
Now, so I was making the submission that if one wants to say that purely formal compliance is enough, one has to say and establish that the statutory provisions construed purposively are content with formal compliance. And in our submission, I was going to say that was a bold argument to run. In our submission, it's just impossible to run. I can illustrate that point by taking a submission made in paragraph 43 of Deutsche Bank's printed case. It's paragraph 43 is at page 595. Thank you. And what Deutsche Bank says there is that there is no support for the proposition. If your lordships want to look at that,
Yes.
as I say,
Page 595.
it's page 595.
These terms give it towards the bottom of the page. Yep.
Paragraph 43.
Yep.
And so what they say is there's no support for the proposition that Part 7 was not intended to apply to cash delivery mechanisms. Now, if you remove the double negative,
Yes.
what they're saying is that Part 7 was intended to apply to cash delivery
Was
mechanisms,
not intended to exclude.
but therefore must have contemplated its application too. But in our submission, that's simply absurd. What is the point of applying the complicated provisions in Part 7 if the substance of the matter is that the employee is being paid cash? Now, neither Deutsche Bank nor UBS has been able to identify any purpose in the statutory provisions that would be served by applying them to cash delivery mechanisms. And Deutsche Bank at least appears to admit that that is what the schemes here in question were. That's, again, paragraph 43. Part 7 of the Act serves a purpose only if the employee is being paid with something that has peculiar features that justify special tax treatment. And a cash delivery mechanism has no such features. The fact that all the securities to which Part 7 applies are capable of being turned into cash at some point at the election of the employee is neither here nor there. The question is, what in substance rather than form is the employee being paid? So if in substance the employee is being paid in cash, there is no purpose is served by applying Part 7 at all. Now that's the point that the employee is getting cash is, of course, our main submission, or our first submission. But if the answer to that rhetorical question is, contrary to our primary submission, that the employees were given shares, then our appeal turns on the alternative, narrow Ramsey argument, that the shares can't be regarded as restricted securities within the meaning of Section 423, because the forfeiture provisions were commercially irrelevant contingencies inserted for tax avoidance purposes. Now, ignoring commercially irrelevant contingencies inserted for tax avoidance purposes is a well-recognised application of the Ramsey principle. It's part of the exercise of looking beyond form and into the substance of a transaction. And the question that has been raised in the present cases is whether or not that, looking at substance rather than form, eliminating commercially irrelevant contingencies inserted for tax avoidance purposes because they don't relate to the substance. The question is whether that has been excluded by the legislation, purposively construed. Now, I've already submitted that there's no basis for the conclusion that the statutory scheme were concerned only with form and they weren't concerned with substance. And there's no basis in our submission for a reading of the statutory provisions that enables one to say that you can just get away with something that ticks the boxes but doesn't address in substance and reality what the statutory provisions are trying to deal with. And I'm now going to consider the different arguments on this point advanced by Deutsche Bank and UBS. In the UBS case, the forfeiture provisions...
Could you just help me on one thing? I mean, just so that I get the factual position clear. The argument is centred around Section 4294C, whether Dark Blue was an associated company. Is that right?
Well,
on the latter, last part of the transaction.
No, that was an argument really about control.
Yes, I see.
That was disposed of in the courts below. Yeah. The narrow Ramsey argument is really about 4232. And it's about the question whether or not what 4232 is contemplating as a restriction is something that is in formal terms a restriction.
Well, I understand that argument, and you've been through that, but I was just trying to look at the last stage where actually the problem, in one sense, arises, because it's only by relying on Section 429 that they avoid the tax charge.
Yes, and
there was the argument there that Dark Blue was effectively an associated company of DB. Why wasn't there an argument that the majority of the company's shares of the relevant class were in reality held for the benefit of employees? Because as I understand it, they were only, they were held indirectly through a chain of companies for the benefit of employees. They weren't, the employees didn't have shares in Dark Blue, but they had shares in Walbrook. Just explain to me. Shares were held on bare trust for them by Walbrook, but they were not shares in Dark Blue. They were shares in a company which owned shares in Dark Blue.
So there wasn't an associated company within the...
yes, but I mean, indirectly, once... is it a matter of timing? Does it turn on the words immediately before that event, or what?
To be absolutely frank, I can't remember now why this was not run. But if it wasn't run, it was for a good reason, because I think
yes.
we
the reality was that the shares were held on bare trust, but they weren't actually the shares in dark blue.
My lord, can I just say, they were shares in dark blue. There was a nominee, but the nominee held shares in dark blue. There was no intervening company.
I see. So, well, that leaves me even more puzzled as to why Section 429(4)(a) wasn't relied on, but you say it was some good reason.
The problem is that it's so far back in time, and I think we ran all the arguments that we thought that we could run, and over time, as it were, the scope of the debate has reduced.
My lord, I don't want to interrupt, but if this might help. The employees of the company referred to are the employees of dark blue.
Yes.
That's the company in which the shares are held.
Right.
Yes.
I may come back to that.
Yes, well, perhaps it can be simplified. Anyway, I will cease to be curious, but...
Cease to be publicly curious.
At all events, when one looks at the forfeiture provisions and the argument about the forfeiture provisions, there's a difference between the UBS case and the Deutsche Bank case. In UBS, it's admitted that the forfeiture provision lacked any commercial rationale, and it was certainly included for tax avoidance purposes. So UBS's response to that is to wave the Abbott and Philbin flag and to point to the fact that you've got other statutory provisions, and they refer to sections 446B and 446E, that refer to things done for a non-commercial purpose. Now, both these points boil down to the single point that, purposively construed, the relevant statutory provisions, which UBS says are sections 4232 and 4252, apply where a forfeiture provision has been imposed solely for artificial tax avoidance purposes. And in making that submission, UBS overlooks the point that I made at the outset of my submissions this morning, which is that the commissioners draw a distinction between things done for a tax avoidance purpose that do actually alter the reality of the situation, and things done for a tax avoidance purpose that don't. Both the Abbott and Philbin and the section...
What is the reality of a situation if something is accepted not to be a sham? That's what's troubling me. I mean,
well,
do we throw up our hands and say this looks thoroughly unreal or artificial? Is that the test?
No, I can't remember which case it is, whether it's Barclays Mercantile or McNiven, where it's said that Ramsey doesn't involve applying a sham analysis.
Yes, well, that's my point. I accept it doesn't. So we must assume that these aren't a sham, that I would have thought the opposite to sham is normally something that's real.
Well...
You say it's not. It can be real things that are unreal.
Well, if you take the example of NMB Holdings, and Lord Hoffman didn't say that it was a sham. Yeah, he just said that viewing it commercially, what they got was cash. So he said that when you look at an event...
All right, so the test is that it's not a sham, but there is a tax purpose and no commercial reality. No commercial sense in what's being done. No commercial sense.
Well, I think what you do is you look at the reality of what is going on. Because in our submission, it doesn't work. If you take the two examples, at one extreme you've got the contention that something is done solely for a tax avoidance purpose. Well, that identifies motive. It doesn't tell you what was done. The Ramsey doctrine is really concerned about what is done.
Well, that's what I was focusing on when I said that element. Is that satisfied by a conclusion by the court that there is objectively assessed no commercial sense in this at all?
Yeah, and it can be. because when you look at it, you can look at it in terms of
tax purpose, of course, which is a big commercial purpose.
but it's not classified as a commercial purpose for these purposes.
No other commercial purpose.
No other commercial purpose.
I mean, this is a fundamental problem that goes right back to Ramsay itself, and why
Yes.
Lord Wilberforce had such difficulty with respect in describing what it was which was going on if it wasn't a sham. But there we are.
But
inherent in the
yes, but in our submission, there are plenty of indications in the cases that show that when you look at a sequence of events, an arrangement, or whatever it is, you are concerned to look in a common sense way and a realistic way at what is actually going on, as opposed to focusing too much on the form or appearance of what's going on. And that's not a sham argument.
No.
It's a different approach to the problem.
It is, but as Lord Mance and Lord Conworth say, once it's not a sham, it's a little difficult to express in clear terms precisely what it is. But you say we can't do better than look at how Lord Nichols put it, and how it was put in one or two other cases. But you say one looks at the reality of the situation.
Yes, and
see how
again,
that fits with the statute.
with the statute. So I suppose I go back to the point that I made at the outset, that one necessary technique is to look at the facts in the round, particularly where the facts, the arrangements are all interconnected. They form a piece.
Yes, I can see how you say you don't divide it up. You look at the whole thing. That I understand.
And so when you, and in this particular instance, we have the advantage that we're dealing with banks and bankers. The employee, therefore, we're dealing with people who have an understanding of a business and of arrangements, and I'm using the word arrangements in its literal meaning. I'm not implying anything pejorative about it. And the employees were told in advance what the scheme entailed. They told what the beginning of the scheme was, they were told what the end of the scheme was. And so in our submission, when you look at the whole thing, all the pointers are pointing in the direction of saying that what this was all about was cash. Because to regard it as being about shares looks, in our submission, just unreal, given all the underlying facts. It's the entire package.
Okay.
Now, I wanted to address firstly the UBS arguments about the forfeiture provisions. And as I said, what UBS do is to rely on Abbott and Philbin and sections 446B and E. But the problem with that argument is that UBS still assumes that in the Abbott and Philbin limb of its argument, that the forfeiture provision actually creates an Abbott and Philbin problem. And so far as sections 446B and E are concerned, they actually are talking about something that really happens. That is to say, a real reduction in market value. The reduction has been brought about by things done otherwise than for genuine economic purposes or commercial purposes. But the value is called an artificially low value in Chapter 3A because of the nature of its cause, not because it doesn't exist in reality. So the problem with my learned friend's reliance on Abbott and Philbin and these provisions is that he's not addressing the target, because he is simply reiterating a point that where, for tax avoidance purposes, something is done, but does bring about a change of substance, then you have got an issue that you need to tackle, Abbott and Philbin, then you have got specific provisions to deal with the situation. He doesn't it doesn't follow from this line of argument that the statutory provisions, when construed purposively, exclude, in all cases, the possibility of ignoring commercially irrelevant contingencies inserted for tax avoidance purposes. And here, when we look at the UBS scheme, we have got, for tax avoidance reasons, the insertion of a forfeiture provision based on an improbable event, that was the finding of the first-tier tribunal, that had no commercial rationale, because the scheme didn't seek to expose the employee to the loss and the risk of loss that justifies the application of Chapter 2. After all, UBS had awarded bonuses to the employees. Now, if for this part of the argument we have to take the bonuses as having been given in shares, the fact remains that they had been earned. And UBS says, admits, that this was a tax avoidance scheme. It doesn't say that this was a scheme that UBS introduced in order to claw back bonuses from employees who had earned them. Now, the substance and the reality of all this was that the schemes were not intended, the UBS scheme was not intended, was not designed as a method enabling UBS to claw back bonuses that had been earned. Now, therefore, when you look at the situation in the round in our submission, we are not dealing with something that can be described as commercially relevant. Now, we fully accept that if you take some of the factors that I've just mentioned individually, and I'll use probability or improbability as an example. Section 4232 doesn't make probability a requirement. But our case isn't based upon just taking improbability out of the context. It's based on looking at all the factors as a whole and drawing a conclusion as to whether or not the restriction was commercially relevant. And under no circumstances in our respectful submission can it be said to have been commercially relevant. And therefore, the scheme does not fall within the scope of Chapter 2. In the Deutsche Bank case, the debate concerning the narrow Ramsey point is slightly different because Deutsche Bank maintain that the forfeiture provisions in its scheme were not commercially irrelevant. And their argument essentially boils down to three reasons, and I take this from paragraphs 54 to 59 of their printed case, and those paragraphs are at pages 599 to 600. The three reasons are these. First, Deutsche Bank says that it doesn't matter for the purposes of the statutory provisions if the trigger event is within the employee's control. And secondly, the reduction in the value of the shares caused by the forfeiture provision wasn't de minimis. And thirdly, they say that the forfeiture provisions were genuine and intended to take effect. They also, like UBS, rely on the proposition that commercially irrelevant restrictions can't be ignored because the legislation doesn't exclude commercially irrelevant restrictions in express terms, and I've already dealt with that point. In order to assess the different factors on which Deutsche Bank placed reliance, it's necessary to look at, in our submission, at them as a whole and in context. And the context was a scheme in which employees participated on the basis that they would avoid tax if they had the self-restraint to avoid activating the trigger event for the short period from the 7th of February to the 2nd of April 2004. It wasn't simply that the operation of the trigger event was in the employee's control. It is that, in addition, the restriction was voluntarily accepted by the employee when he decided to participate in the scheme in circumstances in which he was incentivized to avoid triggering it by the prospect of avoiding paying a large sum of money by way of tax. There's no basis in our submission for believing that the forfeiture provision could be commercially relevant in those circumstances. And we rely in that connection on the passage from paragraph 109 of the First Tier Tribunal's decision that I drew the court's attention to earlier this morning, in which the First Tier Tribunal's realistic view of the facts was that the scheme was closely coordinated in order to transfer funds to the employees as agreed with them. And that finding in our submission is inconsistent with the view that the forfeiture provision was commercially relevant. And therefore, we submit that these appeals ought to be allowed. And unless your lordships have any question for me, those are our submissions. I apologise for the fact that my 1 hour went a little over, but it could be that my mental measure of minutes and seconds is not the same as that of ordinary clocks.
Time is relative. You budgeted for 2 hours, so you were within your original budget. Thank you very much, Mr. Lassock. Ms. Blackwood. Mr. Prosser, you go next.
Thank you. Lords, in my submission, both of HMRC's Ramsey arguments show that they haven't understood the Ramsey principle or approach, despite repeated guidance given by the House of Lords. I refer in my printed case to 4 cases, House of Lords cases, where guidance has been given. That's at paragraphs 53 to 56 of my case, and it's at pages 106 to 107.
Thank you.
In tab F. I won't take you to them, but could I just refer to one of them?
Yes.
And it's the Barclays Mercantile
Yes.
case. And that's at tab 10 of the authorities bundle. It begins at page 1236. Again, I don't think I need to take you to it. It's just a couple of paragraphs. I think it's very well known what the House of Lords said in that case. They said, first of all, at paragraph 33, that Ramsey didn't introduce a new doctrine operating within the special field of revenue statutes. On the contrary, it brought tax law within generally applicable principles.
Yes.
Then they said, the view that in the application of any taxing statute, transactions or elements of transactions which have no commercial purpose are to be disregarded, it goes too far. It goes too far because it elides 2 separate steps which are necessary in the application of any statutory provision. The first is to decide on a purposive construction exactly what transaction will answer to the statutory description. Secondly, to decide whether the transaction in question does so. Then at paragraphs 37 and 38, the House emphasised, by reference to McNiven and Westmoreland, a previous decision of the House of Lords, the need to avoid sweeping generalisations about disregarding transactions undertaken for the purpose of tax avoidance, and in particular, the need to focus carefully upon the particular statutory provision and to identify its requirements before one can decide whether elements inserted for the purpose of tax avoidance should be disregarded. In short, they said, what is required is a close analysis of what the statute means. My submission is that the Revenue have not closely analysed what the statute means in order to identify its requirements. For example, we have not been taken to the definition of securities, which, in my submission, is a very important provision to look at before you can decide whether, for the purposes of the Revenue's broad Ramsey argument, whether what the employees got was money or securities. So I'd like to go through, as briefly as possible, relevant provisions, not of the whole of Part 7, nor indeed of the whole of Chapter 2, but the relevant provisions which, in my submission, are relevant to both of the Revenue's Ramsey arguments. Before I do that, however, I would like to make one point about the historical context of Chapter 2 of Part 7. And it is, as Lord Reid indicated, it is, in my submission, about the Abbott and Philbin problem. I refer to the historical context at paragraphs 20 to 26 of my written case, which is at pages 88 to 91. My submission is that one of the main purposes of Chapter 2 and its predecessor legislation was to prevent exploitation by taxpayers of the Abbott and Philbin principle, the principle enunciated by the House of Lords in Abbott and Philbin in 1961. That principle was that employee benefits, which are convertible into money, however much they may be hedged around with conditions and restrictions, even if the benefits aren't assignable, they are taxable when acquired on their market value at that time, not at a later time. Abbott and Philbin itself concerned a share option, which was non-assignable, was hedged around with conditions, so that its value at the time of acquisition was very low. Nevertheless, the House of Lords held that the employee was taxable on the value of that option at the time he acquired it, and wasn't, as the Revenue had argued, taxable on the value of the shares that he acquired on exercise of the option. Now, until the enactment of the predecessor legislation to Chapter 2, which was in 1998, the Revenue view was that Abbott and Philbin didn't apply to an acquisition of restricted shares or securities, shares liable to forfeiture, for example. Their view was that there was only a charge to tax when the restrictions fell away, when the shares ceased to be subject, for example, to the risk of forfeiture on their value at that time. But in 1998, the Revenue received fresh legal advice that the principle, the Abbott and Philbin principle, did apply to the acquisition of restricted securities, restricted shares. And it was at that point the government decided to change the law, in part to prevent exploitation of the principle. Now, may I refer to, very briefly, to the explanatory notes, which are at tab 25 of the bundle of authorities, just 2 paragraphs of that, which prove my assertion to be correct, that that was one of the purposes of this legislation.
Thank you. Yep, which page?
It's page 1893.
Thank you. Right at the end, thank you. Yep.
It's headed, sorry, it's not page 183, it's 1887. 1893 is the press release that accompanied it, which the upper tribunal referred to in there.
1887,
But I thought I should refer to the
Yes, okay.
explanatory notes at 1887.
Yep.
The summary at the top. This clause provides that where an employee or director receives shares on terms which mean they may later be forfeited, there shall not be an income tax charge when the shares are first acquired, unless the shares can still be subject to the risk of forfeiture for more than 5 years later, and so on. It says the charge will be on the market value of the shares less deductions when the forfeiture is lifted. And then paragraph 2, this change will ensure that such share schemes are taxed on a fair basis and give legislative certainty to businesses planning to set up such schemes. The legislation also closes a potential avoidance opportunity, which could have been used to provide employees and directors with tax-free remuneration.
Yeah.
And then the background at the end on pages 1890 and 1891
Yeah.
explains what the Revenue's view used to be, and paragraph 31 at the end says the Revenue's view now is that the income tax charge under normal rules arises at the time when the shares are first awarded. So there is...
On the value taking into account the risk of forfeiture.
So that the Revenue accepted the application of Abbott and Philbin meant that employees would only be taxed on the lower value of the shares or other securities when they were acquired, and that was a problem. It wasn't just a tax avoidance problem, but it was a tax avoidance problem. They recognised that tax could be avoided by giving employees shares and other securities with restrictions attached, which would devalue them, and therefore the employees would only be taxed on that lower value and not on a higher value when the restrictions fell away. Now, the finance Act 1998 provisions, I won't take you to them, but if I can tell you, they're at tab 4 of the authorities bundle, which begins at page 1132. In 2003, when the Consolidation Act, the Income Tax, Earnings and Pensions Act 2003, ITEPA, was enacted, the 1998 provisions were reenacted without any substantive amendment into Chapter 2 of Part 7. If I can take you to that, that's in tab 6 of the authorities bundle, beginning at page 1140.
Yep.
So that this is effectively what had been enacted in 1998
Right.
and carried through to 2003. It's headed conditional interest in shares, although shares are defined by section 434, if one goes to page 1148,
Yes.
to include securities, but securities aren't defined.
Right.
So it's securities in the ordinary sense.
Understand.
Going back to section 422, this chapter applies where a person, the employee, acquires a beneficial interest in shares in a company as a director or employee of that or another company, and the interest is acquired on terms that make it only conditional. Come back to that in a second. Just to see the contrast between the original Chapter 2 and the one that we're interested in, not only have we got a very wide definition of securities, which I'll take you to, another change which reflects the desire to prevent exploitation of the Abbott and Philbin principle is that section 4221 is where the employee acquires the shares. And when we go to the replacement part 7, we see it doesn't matter who acquires the shares or other securities. All that's important is that they're acquired by reason of someone's employment. So it's a much wider provision. And then section 423 tells us when shares are acquired as a director or employee. Don't you look at that? 424 is when it's only conditional, and that's pretty well the same language in subsection 1. If certain circumstances arise or don't arise, there'll be a transfer and so on, and that you won't get an amount equal to market value at that time. So the consequence of all that, section 426, is that there's no charge in respect of acquisition.
Yes.
So that removes the Abbott and Philbin charge on the lower value.
Yes.
It's replaced by a new charge under section 427.
Yeah.
That's when they cease to be conditional or on their disposal.
Yes.
Now, and then 428 tells you what the measure of the charge is. Effectively, it's market value at that time. There is, importantly, no exemption, no equivalent in the original Chapter 2 of what we now see as section 429. There's no exemption from that charge when the restrictions fall away. So that's the one difference, really, the important difference in terms of the basic structure of the legislation.
Yeah.
If I can then take you to the replacement part 7, which came in 10 days after the original ITEPA was enacted. So the original ITEPA came into effect from the 6th of April 2003. It was 10 days later, as from the 16th of April, effectively replaced by a new Part 7. And that's, as we've seen, in tab 2 of the authorities bundle. And as I say, the broad structure is the same.
Is there an explanatory note for this?
No, there isn't, as far as I'm aware, no. It's consolidation.
Well, it wasn't the...
Oh, sorry, the new one. No, I'm not aware that there is, or that it casts any light at all on the issues that we're interested in. So Chapter 2, on page 1088, we have section 422 tells us when the chapter applies. This chapter applies to employment-related securities if they are A, restricted securities, or B, a restricted interest in securities at the time of the acquisition. My submission is that's what you need to look at. We didn't look at that earlier on. That's what you need to look at to decide whether or not Chapter 2 applies, to see whether those conditions are satisfied. And I think the one that is has been identified so far as the revenue are concerned, and their broad Ramsey argument is whether what the employees acquired were securities.
Yeah.
We'll come on to that, and I'm not going to go to the definition yet, but the important point is that we get the Abbott and Philbin problem dealt with in the same way, broadly, that Section 425 says there's no charge in respect of acquisition. 426 through to 428 then impose a replacement charge on effectively market value when the restrictions fall away. But then we've got the new Section 429.
Yes.
And my submission is, if this legislation is defective, if it doesn't apply to give rise to a charge when one would expect it to, it's not because of anything in the definition of securities, which are incredibly wide, or anything else. It's in Section 429 and the exemption, which for my part, although I listened to Mr. Lassock, I do not myself understand what the policy purpose of Section 429 is. In particular, it's not the case that the condition in subsection 4 is that a majority of the shares of the class are not held by or for the benefit of employees. Because, as was pointed out by Mr. Goy, it's employees of the company. And the company that's referred to there isn't the employing company, of course it may not be a company, it's the company in whose shares the employee holds.
Yeah.
So why is it that one is giving an exemption in those circumstances? I don't myself understand it, but that is the defect, if there is one, in this legislation. And I should also mention, this couldn't be said to be a one-off legislative.
So here it's dark blue.
Yes.
In my case,
Yeah.
it's a company called ESIP Limited.
Or
if I'm acting for UBS.
it's all easy.
Yeah.
That is the company. Yeah.
Yes, that is the company, yeah.
Yep.
And therefore, when one goes through the various paragraphs A to E of subsection 4, one is still focusing on ESIP Limited. For example, in C, associated companies of the company. Persons who are E, related to an employee of any such associated company and so on. The starting point is the company is ESIP Limited,
Yes.
not UBS.
We understand. Yep.
The other point I wanted to make was this isn't a one-off exemption. It appears throughout Part 7. So it's obviously a deliberate policy decision, but as I say, I can't work it out myself. It comes up in Chapter 3, Chapter 3C, and Chapter 3D. So it is an exemption which... Now, but what follows from that is Parliament must have intended that if any, so far as Chapter 2 is concerned, Parliament must have intended that if an employee acquires restricted securities as defined, and this 429 condition is satisfied, and it's common ground that it's satisfied here,
Yes.
Parliament must have intended there should be no tax. Not only when the shares are acquired, but also when the restrictions fall away. That must have been Parliament's intention, that you could acquire these shares tax-free, providing you satisfied the conditions. The result being that all the employee would have to pay is capital gains tax, because he would have, let's suppose, acquired the shares for nothing and sell them when the restrictions fall away for 100 or whatever. He would pay capital gains tax on the 100.
Understand.
So then, can I now take you to the relevant provisions of Chapter 2? I've taken you to Section 422.
Yes.
If I can just go back to that very briefly. As I say, I believe that the revenue's case is that the particular condition which isn't satisfied for Chapter 2 to apply, as far as their broad Ramsey argument goes, is that these are not securities.
Understand, yes.
Then could I take you to the... I beg your
effective.
I think I may have suggested that.
Well-
I suppose that is one way of putting it, and I would be to focus on the phrase employment-related securities.
Yes.
But one way or another,
Yes.
to say that this, what we're dealing with in this case, isn't the sort of creature
Yes.
that the legislation had.
But in my respectful submission, when you say one way or another, that's fine, but it has to be one or other of those ways in Section 422. It's no good simply saying this isn't the sort of thing that Parliament intended Chapter 2 to apply to. This is... The fact that it's prescriptive legislation suggests that when Parliament enacted Section 42, it meant it, that Chapter 2 should apply in those
Is
circumstances.
that where we look at the definition of securities?
We do now, yes. So we have to go back there to Chapter 1.
Thank you.
and section 420.
So I see. 1083, yep, thank you. Yep,
So this is for the purposes of Chapter 1 and Chapters 2 to 5.
yes,
The following are securities. First of all, shares in any body corporate.
yes,
It doesn't say a body corporate which exists for a particular purpose, a commercial purpose, or a particular business purpose, or it doesn't say it doesn't include an SPV. That was one of the points Mr. Lassock made. That, in my submission, cannot be right. It shares in any body corporate. Yeah. Then debentures, debenture stock, loan stock, bonds, certificates of deposit, and other instruments creating or acknowledging indebtedness. Now, as we see immediately how much wider this is from the original chapter, chapter 2. Mr. Lassock also made a point. He said, what we're really interested in is securities which serve a commercial function. Well, what would be the commercial function of giving an employee a certificate of deposit? My submission is it's not about securities which serve a commercial function. It's about, as I've mentioned it, the Abbott and Philbin problem, giving employees something which actually isn't money, but which is an asset of another kind, which can be turned into money, but which, because you've restricted it, reduces its value. And as a result of that, the tax charge is less than Parliament thinks, subject to the Section 429 exemption, it ought to be.
In McNiven, the problem for the taxpayer wasn't that what he'd been given wasn't chemically platinum sponge. It met all the requirements of platinum sponge. The problem was that in commercial reality, what he was being given was cash.
Yeah.
And I think the argument of the revenue here would be that, by analogy, it doesn't really matter whether these shares meet the definition of a security or not. In reality, what's being given here isn't securities, it's cash.
Well, but that argument, with respect, doesn't meet my point that Section 422 tells you that if you satisfy those conditions, including that these be securities, this chapter applies. It's no good saying, well, that doesn't matter, because if in a broad sense you can say the employee is getting money, looking at it in overall terms, then that disapplies Chapter 2. That wouldn't be, in my submission, construction. That would be legislation.
Are you saying effectively they could have given him a certificate of deposit? And that would have been enough? Albeit subject to conditions, which would have...
Yes, exactly. That's what I am saying. That is what I am submitting. Of course, in NMB Holdings, the legislation, this wasn't the legislation that the court was looking at. The legislation there was simply whether the employee had received a payment.
Yes. What I'm examining, if the certificate of deposit was repayable in a certain date, but was also subject to a condition of forfeiture and so on.
Yeah.
Your point is that it would still undoubtedly be a security, even though it was effectively cash, because it was a promise to pay a sum of money at some point in the future.
Yes, or debenture.
Debenture, similarly.
A debenture. Now, I did accept in the Court of Appeal that one could, because I haven't come to it.
Certificate of deposit is, I suppose, a debenture from a bank is similar to a certificate of deposit, like money in the bank.
Yes, it is like money in the bank, and the legislation doesn't distinguish between debentures which are risky and others which are safe.
Well, certificates of deposit.
No.
Yep.
I did accept in the Court of Appeal that there is a tension, a potential tension, between these definitions of securities in subsection 1, because subsection 1 begins subject to subsections 5 and 6.
Yes.
And subsection 5b, which 5 says the following are not securities: A, checks and other bills of exchange, and so on; B, money, and statements showing balances on a current deposit or savings account. So that clearly there is some potential tension between something that on the one hand might be regarded as falling within subsection 1, but then is taken out by the word money.
Yes.
I accept that, but it cannot follow from that in my submission that all debentures, because they give a right to a sum of money at a certain date, are money and therefore cannot fall within B. That would mean that B has really no work to do. So that I accepted in the Court of Appeal that if one, for example, was given shares, or debentures for that matter, which were redeemable and to be redeemed within a day or so, let's say, for a fixed amount of money, carrying no rights to dividends, no rate of interest, then perhaps that would be the sort of occasion where one would say, in reality, what you have got is money and not debentures or shares. I accepted that because of that tension. But for reasons I'll come on to, I don't accept that that is the position here, given the nature of the shares which the employees were given. And it is the nature of them that counts, because that is what the definition is addressing, the nature of what you're given. Is it debentures, for example? Not the intention, the concern, as Mr. Lassop put it, that the parties have, whether they're really concerned about it giving the employees at the end of the day money. If you give an employee a debenture, he knows, you don't have to tell him perhaps, but suppose you do emphasise to him, of course you can turn this into money when it's redeemed. That doesn't matter. It's the nature of the security that counts. That's all that the legislation is interested in.
Isn't one looking at anything broader in terms of Ramsey, ever? I mean, it seems to me here the argument against you is that no stage of this transaction has any commercial sense at all. That applies at the beginning. There's nothing in the provisions relating to forfeiture. And right at the end, the reality is that although you get within the technical language of Section 429, it's only because there are a whole lot of other shares issued in, I must get the right company, in ESIB, which don't have any commercial
No, it's
value
not because
at all.
of that at all, actually. As far as 429 goes, it's nothing to do with other shares. It's just because, as I mentioned, that 429.4 talks about employees of the company. In fact, virtually all the shares of the class were held by UBS employees. But that doesn't matter. It's nothing to do with other shares.
Yes.
Well, but your point is...
Well, I thought the majority... Yes, I see.
Its majority of
Not
shares
held
are not held for the benefit of employees of the company.
Yeah.
When you see that the company means ESIP Limited,
Yeah.
none of the shares were held
Yes, I see.
for the benefit of
with you.
employees of
I'm
ESIP
with you.
Limited, but they were all held by employees, apart from a couple which were held by a trust. They were all held by employees of UBS, but the legislation isn't concerned with that. So,
No.
your earlier point was...
I mean, see, yes, it seems... Sorry, go on, yes.
No. Well, if I can address your earlier point, which is this is all about, should be all about reality. There was no commercial sense to this. I accepted below, and I still accept, that this was done for tax reasons and that the restriction was imposed for tax reasons. And that's why I said in the FTT there was no commercial rationale for imposing the restriction. That was intended to avoid the need for cross-examination of witnesses and so on. But my submission is that's completely irrelevant to the application of this legislation, which is not concerned with the reasons you do things. It is actually, one of its purposes is to deal with the situation where you do things for tax reasons, and they do have an effect on value, which would remove part of the tax charge because of Abbott and Philbin.
Yep.
One could imagine a situation where shares weren't able to be redeemed for 2 years, let's say. And in the case of UBS, 50% of the shares weren't redeemed for 2 years. Now, why would one say in that case that in reality you haven't received securities when they're capable of lasting for 2 years, and they do last for 2 years, and in the meantime you receive dividends? The amount you receive on redemption has got nothing to do with the amount which has been subscribed for them. It's all to do with the value of the company, which has invested its £90 million in quoted shares. Why would you say in that case that what you've received are not really shares? All one would say is, but this has no commercial sense. You didn't do it for commercial reasons. But that goes back to my earlier point, that a close analysis of the statute does not require that you do it for commercial reasons.
Are we going to look at the Platinum Sponge case, or?
Well, I wasn't going to, because it says nothing at all about this legislation.
No, but I mean, it was obviously regarded as relevant by Ian McNiven. But I was just looking at it, it's in tab 18, that there, the money went into and out of Platinum Sponge in the course of 24 hours.
Yeah.
So it's a rather different.
It is a different
factual
situation. Factually, yes. That's why I would accept, even on this particular legislation,
That's
if there were...
E1625.
No.
Yes.
If one did have a situation where within 24 hours, something that appeared to be a security was preordained to be turned into cash, one would have a very powerful argument for saying, actually, the override in subsection 5b operates. But I'm saying, factually, that cannot be said here, and the mere fact of the tax purpose cannot alter that question, which is one of the fundamental, the real nature of what you've got. And that was why, in my submission, in NNB Holdings, it was regarded as a payment of money, not because of the intention with which it was done, but because of the nature of what, in reality, the employee had acquired, given that within 24 hours it had turned into cash. I think Mr. Goy is going to take you to NNB Holdings, if that would be helpful.
Well, I think that was the only point I thought might be interesting.
Yeah. Just before we leave section 420, subsection 5a, although it takes some things out of the definition of securities, it doesn't take out bills of exchange accepted by a banker. So again, we've got something which, of its nature, looks like very much like the equivalent of cash, if it's a bill of exchange accepted by a banker. But the legislation expressly has provided that that is still within the definition of a security, notwithstanding 5a. What I didn't look at back in subsection 1c, d, e, f and g are all the other things which are treated as securities. And the reason that is not because employers were regularly giving employees futures and rights under contracts for differences as part of a commercial arrangement. It was because they were doing that to exploit the Abbott and Philbin principle. They knew that these futures could be turned into cash, but they were relying upon the proposition that the value being reduced was the measure of the tax charge. Yeah. That's the purpose of this legislation, to catch a wide range of assets, which, yes, they're going to be turned into cash, and they're being given for tax purposes, but nevertheless the legislation intends to apply to them.
But if cash is excluded, and we were to conclude that Mr. Lassock was right, and really this whole transaction was aimed at giving the employees cash, why isn't that inconsistent with the purpose of the legislation? Simply because of the factors you've identified.
Well, okay. So if I am an employer and I decide to give my employee a debenture, and there's nothing more to the arrangement than that, I know that the debenture will be redeemable in 1 year's time. Mm-hmm. Does that mean that this is all about cash? Because that's true with every debenture. How long does the debenture have to last for before you say it's not really about cash?
So is it right that you don't really look into the parties' minds at all?
No. No, you don't.
You simply say, does this fall within the words of the section? Because, as you say, if debentures are covered and certificates of deposit, what's the problem? Well, they would be cash even more, you would say, than the present rather cumbersome arrangement, or more cumbersome, or more less familiar arrangement. Yep.
Yes, certainly so in my submission, because, of course, in our case, you don't know the amount of cash that you're going to get at the end. And that is one of the difficulties I would submit for the revenue in saying this is all about cash. A determination was made for the year 2003-04. What's the amount of cash that you regard the employees as having got? Is it the amount that UBS has subscribed for the shares? Well, the employees haven't got that cash. That was one of the arguments that was abandoned below, that they are to be treated as having redirected cash by saying to UBS, please subscribe for the shares on our behalf. That argument has been abandoned.
If you simply handed them debenture stock, that would be chargeable at once, would it? You wouldn't wait till the debenture was redeemed, or would you?
Well, on the revenues argument.
No, on your argument.
My argument, well, if it's a debenture stock, then you apply this legislation because it's security.
And well, how would it work? You're my employee, I give you a debenture stock. It's going to be redeemed in a year by the company on which it's secured.
Sorry, I'm assuming that it's been restricted, and therefore...
If it hasn't been restricted...
Okay, it hasn't.
Then it's just charged, then it's immediately taxable.
Yes, and there's no Abbott and Philbin question, because there's no restriction.
No.
But if it has been restricted, Parliament wanted this legislation to apply to it in order to...
Right.
one might say Parliament assumed that something which was a debenture couldn't be treated as money and treated as a payment of money. And my submission rightly assumed, because a debenture is not money. It may be as good as money, but it is not money. You haven't paid someone money when you give them shares in a company or debentures, unless, for example, it's got such a short life that you can't regard it as an asset in its own right at all. All it's good for is the money that will come out very shortly afterwards. Even then, incidentally, if one goes to subsection 8 of section 420, because this legislation applies not just to securities, but also interests in securities, subsection 8 says, means an interest in less than full beneficial ownership and includes an interest in proceeds of their sale. So even if your only interest that you're given is an interest in the proceeds of sale of a security,
Yes.
that is still something this legislation wants to bite on.
Yes, I understand.
Now, what are the factors then that Mr. Lassock says entitle you to say this is really about cash and not about securities? We've looked at the nature of the securities, and can I take it that you know the broad facts in relation to the UBS scheme, that these were shares that were redeemable at the option of the employees. Some of the employees held them for over 2 years, as I said. The amount payable on redemption depended upon the value of the assets, the net assets of the ESIP company at the time of redemption, and that in turn depended upon the upward or downward movement of the value of those assets, which weren't cash, they were quoted UBS shares that ESIP was required to invest its 90 billion of assets in. So the amount that the employees could get on redemption wasn't a fixed amount, it was an amount that could go up or down and did in fact go up and down.
Yeah, but that was largely, yes. Yes, I mean, the variation would be largely due to the incidence of CGT, wouldn't it? I mean, some of the employees would be liable to CGT, others wouldn't, and if you were, it made sense to hang on to them for 2 years to get taper relief.
Yes, Mr. Lassock suggests that because people held on to them for 2 years to get taper relief, that's somehow a reason to ignore the fact that they could be and were held for 2 years. I don't know why that is. Taper relief was held out by Parliament to encourage people to hang on to their assets for 2 years, in which case the rate of tax would go down. Why that should be held against the employees, I don't understand. But the point is, in terms of the nature of the shares, that if you did hang on to them, the value could go up or down because of the nature of the assets that ESIP had invested in. In the meantime, the shares carried a right to participate in dividends. And the amount of dividends, again, would depend upon the profits of ESIP Limited. So these did function as shares. They were miles away from a right to a fixed sum of money, albeit payable in future.
Understand.
The only thing that was different from ordinary shares, they didn't carry votes. They were non-voting ordinary shares.
Is there, I mean, Mr. Lassock put some emphasis on the findings of the first-tier tribunal, which in fact are not quite the same in your case as they are in Mr. Goy's case. No. Should we attach any importance either to the findings generally or to the differences between in the two cases?
Well, I was going to say he didn't make an equivalent finding as far as UBS. He didn't rely upon an equivalent finding in relation to UBS.
Yes, I wonder if you were going to say you were better off on that respect.
I wasn't going to boast about it. But there isn't that finding.
But you just have done it.
I'm required, on behalf of my client, to point out.
Of course.
That
But to what extent are we concerned with the findings of fact of the first-tier tribunal?
Well, the first-tier tribunal effectively said these are real shares, in both cases. This is a real restriction. It genuinely depresses the value of the shares. When they made that finding, they were basically saying, simply, this is a tax avoidance scheme.
Yeah.
That's really what they were saying. It wasn't any more specific than that. And that's been the attack. Although Mr. Lassock rose this morning and said, well, that isn't really my case, actually that has been his case throughout because of all the features that he relies upon, so far as his broad Ramsey argument goes, to say these aren't securities, is fundamentally pointing out the lack of commerciality. In other words...
So you say the FTT really got it wrong because they approached it in the wrong way?
They approached it in the wrong way, I would submit, if I can represent Mr. Goy as well as myself. in that they were focusing on the wrong thing. They were focusing on the intention or purpose behind the arrangements rather than the objective nature of the arrangements themselves, which were to give people shares which of their nature were redeemable. And that was it. That was the scheme.
But you presumably rely on their findings that they were real shares and real
I do. They're agreed facts. They are in the agreed statement of facts. That they're real shares, and that isn't a company law point the FTT was making. That was a Ramsey point.
Understand? Yep.
So that Mr. Lassock has talked less about the nature of the shares, because that isn't helpful for him when you look at section 420. He's concentrated on the intention with which they've been awarded. In my submission, that isn't relevant. Or with which they're held. In other words, they're held to get taper relief. That's not relevant. He's mentioned that the full details were explained to employees, as if somehow, if the employees are kept in the dark, that makes it less objectionable. Obviously, the employees were told, these are the times that you can redeem the shares. I would submit there's nothing wrong with that, and it doesn't alter the nature of what they got. It doesn't prevent them being securities. He says this wasn't a rational investment opportunity. I'm just quoting from all the things he said this morning. It wasn't a rational investment opportunity. Again, my submission is there's nothing about the definition of securities which requires it to be a rational investment opportunity. I've given the example of a certificate of deposit. One can give all sorts of examples of why would an employee be given futures in orange juice or sides of beef or something. The answer is, it's by and large, it's a tax arrangement rather than an investment in the ordinary sense. The fact that if the employees hadn't got the shares, they'd have been given cash, that's true. That they were given a choice. Would you like cash or would you like shares? That can't make a difference, again, to whether when they choose shares, they've got securities within section 420. The fact that the scheme begins with cash, in the sense that UBS subscribes for shares, and it ends with cash in the sense that the employees redeem their shares. Again, it's very easy just to say, well, look, as Mr. Lassock did say, cash in, cash out. That's far too broad a view, because in the meantime, this period covers over 2 years, in some cases, the employees have got securities. And moreover, it's not the same amount of cash, and one can't, at the moment of acquisition, predict what the amount of cash will be. And I would submit that's a real problem for the revenue in saying this is cash. They haven't identified what the amount of cash is or the basis of identifying that amount. I think they would say, well, it's the amount of cash that you would have got if you hadn't chosen shares, or the amount of cash subscribed for the shares. Why is that the measure of what the employees got? Mr. Lassock also...
Just getting my understanding of the facts right, the first tribunal did make findings against you on reality, didn't it? Which were overturned by the upper tribunal. Admittedly, it ended up saying tribunal doesn't consider that in reality the scheme can properly be described as one providing restricted securities within the scope of Chapter 2, Part 7 of ITEPA. Yes. But that was overturned.
That's all that came down to, as the upper tribunal said, was saying this is a tax avoidance scheme. That's all the reality was. It's not the sort of scheme, looking at its reality, that Parliament intended should be within the scope of Chapter 2.
But it wasn't it was a little bit more sophisticated than that, wasn't it? I mean, didn't they say it didn't fall within Section 4232C because the hedging had the consequence that in reality the amount received in respect of the securities wasn't going to be
they did.
Value.
Yes, they did do that. That's quite right. That argument by the revenue has been abandoned now. That isn't part of their case. So that the hedging arrangements are, I know that Mr. Lassock relies on them to show the overall lack of commerciality, but they're not in themselves relevant to any particular point of construction.
That's the particular conclusion, but the reasoning in the previous paragraph seemed to be, look at the whole scheme, it's totally unreal commercially, and the only reason it exists is tax.
Well, I've admitted countless times the only reason for doing it was tax. My submission is that is irrelevant.
Yeah.
And as is its total uncommerciality.
Well, that's just another way of saying, surely, that it's being done for tax.
No other reason.
Well, that's not quite right. I mean, people do real things for tax reasons.
Right. Well, if we're looking at reality then, these were real shares. The tribunal, the FTT said that.
We then come back to the fact that nobody's saying it's a sham. And you're saying once it's not a sham on this statute, if you're within the literal wording, end of story.
I'm not quite saying that because, as I said earlier on, there is a tension between things being shares or debentures on the one hand and money in finance.
Well, yes, but then it's not within the statute.
Right.
Because
Yes, apart from
it
sham.
would have been within the statute
Yeah.
if it had been within subsection 1, but it's then taken out by subsection 5.
Yes.
Yeah.
Well,
That's pure statutory construction. There's no... Yes, I see.
would that be a convenient time?
How are we doing in terms of time?
I'm within my time schedule.
Well, I think you've got another quarter of an hour, I think.
I think I've got half an hour, actually.
No, you had
I've
an
got
hour.
till...
Quarter past he finished. He finished at quarter past. You can't benefit from his...
Oh, I see. Okay. Well, if I promise to be finished at quarter past, can I do what Mr. Lassock did and carry on for half an hour?
No, it's our time that matters, not yours or his. You started, we'll resume at 2, and you've got a quarter of an hour. Thank you.
Yep.
Court will adjourn. Court's now adjourned.